Judgment in the appeal of the Queen on the application of Prudential plc against the Special Commissioner of Income Tax.
This appeal concerns the scope of legal advice privilege. Legal advice privilege applies to all communications passing between a client and its lawyers acting in their professional capacity in connection with the provision of legal advice. The specific issue raised by this appeal is whether, following receipt of a statutory notice from an inspector of taxes to produce documents in connection with its tax affairs, a company is entitled to refuse to comply on the ground that the documents are covered by legal advice privilege in a case where the legal advice was given by accountants in relation to a tax avoidance scheme. The more general question raised by this issue is whether legal advice privilege extends or should be extended so as to apply to legal advice given by someone other than a member of the legal profession, and if so, how far legal advice privilege thereby extends or should be extended. The facts giving rise to this appeal are as follows. In 2004, PricewaterhouseCoopers, PwC, the accountants, devised a marketed tax avoidance scheme, which they adapted for the benefit of the Prudential group of companies, which implemented the scheme through a series of transactions, which the Inspector of Taxes considered it necessary to look into. To that end, he served notices under Section 20, capital B, of the Taxes Management Act 1970 on two companies in the Prudential group that I'll call Prudential. The notices asked Prudential to provide him with specified classes of documents. Prudential refused to disclose certain documents, the disputed documents. This refusal was on the ground that Prudential was entitled to claim legal advice privilege in respect of the disputed documents because they related to the seeking by Prudential and the giving by PwC of legal advice in connection with the transactions. The inspector then formally required Prudential to disclose the disputed documents. Prudential issued an application for judicial review challenging the validity of those notices. Mr. Justice Charles rejected Prudential's application on the ground that although the disputed documents would have attracted legal advice privilege if the advice in question had been sought from and obtained from a member of the legal profession, no such privilege extended to advice, even if identical in nature, provided by a professional person who was not a qualified lawyer. His decision was upheld substantially for the same reasons by the Court of Appeal. Prudential then appealed to the Supreme Court. By a majority of 5-2, we dismissed the appeal. The majority of the court is of the view that legal advice privilege should not be extended to communications in connection with advice given by professional people other than lawyers, even where that advice is legal advice which that professional person is qualified to give. Such an extension would extend legal advice privilege beyond what are currently, and have for a long time been, understood to be its limits. The majority is of the view that it is universally believed that legal advice privilege only applies to communications in connection with advice given by members of the legal profession. However, this view is not shared by the minority of the court, who consider that legal advice privilege extends to advice given by members of a profession which has, as an ordinary part of its function, the giving of skilled legal advice. There are three key reasons why the majority is of the view that legal advice privilege should not be extended in the manner contended for by Prudential. First, extending legal advice privilege to any case where legal advice is given by a person who is a member of a profession, which ordinarily includes the giving of legal advice, but is not a lawyer, would be likely to lead to a clear and well-understood principle becoming uncertain. It's unclear which occupations would be members of a profession for this purpose. There would be room for uncertainty, expenditure, inconsistency, if the court had to decide whether a group constitutes a profession for the purpose of legal advice privilege. It is also unclear how a court would decide whether a profession or part of a profession is one which ordinarily includes the giving of legal advice. Where members of other professions give legal advice, It will often not represent the totality of the advice, so it may well be difficult to decide how to deal with documents which contain legal and non-legal advice. Second, the extension of legal advice privilege to cases where legal advice is given by someone who is not a qualified lawyer raises a question of policy which are best left to Parliament. The consequences of extending legal advice privilege beyond what it is currently understood to be should be considered through the legislative process with its wide powers of inquiry, consultation and democratic accountability. The extension of legal advice privilege to professions other than lawyers may only be appropriate, for instance, on a conditional or limited basis, which cannot be appropriately assessed, let alone imposed by the courts. Thirdly, Parliament has on a number of occasions legislated in this field on the assumption that legal advice privilege only applies to advice given by lawyers. Therefore, it would be inappropriate for the Supreme Court to extend the law.